All right, let's get right into it. When you think about winning a court case, you probably picture mountains of paperwork, right? Hours of testimony? Well, what if I told you that an entire disability discrimination case can sometimes turn on just a single piece of evidence? Today, we are going to unpack exactly what that keystone document is.
It really does sound like something straight out of a movie, doesn't it? The classic smoking gun that blows the whole case wide open. But this isn't fiction. We're about to look at a specific type of evidence that can completely, and I mean completely, dismantle an employer's defense, leaving them with absolutely nowhere to go. So where does this killer piece of evidence actually come from? Well, it all starts with a UK government scheme, and it's called Access to Work.
Now, the key phrase here, the one you really need to pay attention to, is publicly funded. This isn't just some vague set of recommendations. We're talking about a program where the government literally gives money to the employer to pay for adjustments. The entire point is to make the workplace accessible, at little to no cost to the company itself.
And you know, the whole process is designed to be super straightforward. An expert comes in, figures out exactly what the employee needs. They write up a report detailing everything. Then the government just gives the money to the employer. The employer has one job: take the money and do the thing that's already been planned out and paid for. Now remember how simple that is, because that simplicity is the key to this entire argument. Okay, so let's see how this incredibly simple process becomes an absolutely airtight legal argument. This evidence has its most direct and, honestly, its most devastating impact on the main claim in these cases: the failure to make reasonable adjustments. To win a claim like this, an employee has to prove a few different things. You can see them there on the left. And this is where the DWP evidence, that's the Department for Work and Pensions, becomes so incredibly powerful. Did the employer know what was needed? Well, yeah, they applied for the funding. Was the adjustment reasonable? Of course it was. It was literally free for them. This evidence just goes down the list and ticks every single legal box. Boom, boom, boom. So you might be wondering, what on earth could an employer say to defend themselves? Well, that's the thing. They really can't. They can't claim they didn't know what to do because they were part of the assessment process. And they certainly can't claim it was too expensive because the government was footing the bill. Every single one of their usual excuses just vanishes.
But it doesn't stop there. Not even close. This is where it gets really interesting. That one single piece of evidence starts a domino effect, and it begins to knock down the defenses for a whole bunch of other claims too.
Just look at this chain of events. It's an unbroken line of cause and effect. This proves a whole other claim called discrimination arising from disability. The logic is just crystal clear. The employer doesn't use the funding they were given, which directly causes the employee's performance to drop, and then the employer uses that poor performance as the very reason to fire them.
And this quote from the source material just says it all, doesn't it? They created the disadvantage, then punished you for it. The employer is basically penalizing the employee for a problem that they had the fully funded means to solve, but just didn't.
And the evidence also backs up claims of direct discrimination. I mean, when you put the treatment side by side like this, the picture couldn't be clearer. The disabled employee had support funded, but it was withheld, and they were dismissed. A non-disabled colleague in a similar role, they were kept on. It paints a very, very obvious picture of less favorable treatment.
And the ripples just keep going. This evidence can even support a claim of harassment by showing a pattern of neglect that creates a really hostile environment. And what if the employee gets fired right after making a formal complaint about all this? Well, that starts to look a lot like victimization. It suggests this wasn't just some oversight, it was a deliberate course of action.
So what we're really looking at here is a legal checkmate. It's the perfect move. This one thread of evidence anticipates and counters every single excuse the employer could possibly come up with. They literally have no good moves left to make.
I mean, just think about it. They can't say they didn't know. They can't say it was too expensive. They can't say it was impractical. They can't even try to argue the employee didn't ask for help. And maybe the most critical part, they have no paperwork of their own to contradict the facts. It is just an incredibly tight case. And then you get the final twist. What happens if the employer tries to get rid of this evidence, tries to hide it or destroy it? Well, that actually makes everything so much worse for them. It strongly suggests a guilty mind. It shows they knew they were doing something wrong. It shifts the whole story from simple negligence to a potential cover-up.
So, let's bring this all home. What are the real-world consequences here? Why does this single document matter so much when all is said and done?
What all comes down to the money. This kind of evidence doesn't just help you win the case, it drives up the compensation. Because it proves the employer's actions were deliberate and sustained over time, it can push an award for injury to feelings into the highest possible band. It can also justify aggravated damages, which are awarded for particularly malicious or oppressive behavior. And then there's this number, 25%. That represents a potential uplift on the entire compensation award. It's a penalty that tribunals can slap on an employer when they've unreasonably failed to follow fair procedures. And honestly, what could possibly be more unreasonable than ignoring a fully funded, expert-designed solution to support your own employee?
So we'll leave you with this one final question to think about. When the path to do the right thing is not only clearly laid out for an employer, but is also completely paid for with public money, and they still choose not to take it, is that just a simple failure, or is it a conscious choice? The evidence really does seem to speak for itself.